Hello, my name's Alex Viduris. I'm a lawyer with Pace Law Firm, and today with me is my friend Jim Anagnostopoulos from Access Rehab. Hi Jim, how are you today?
How are you? Thank you for having me.
All right, today Jim and I are talking about the MIG, or minor injury guideline. The minor injury and the minor injury guideline came into effect with the amendments to the SABS, as you know, Jim, in the Statutory Accident Benefit Schedule in September 1st, 2010, and it limits recovery of medical and rehabilitation benefits to $30,500. So far, so good, Jim.
Yeah.
And but you are a treatment facility, and you're also providing medical reports and support for injured people. How has this new MIG legislation, we'll call it, how has that affected your side of the industry?
Well, the minor injury guideline is a specific guideline that was designed to treat people within a timely fashion and not absorb a lot of cost within the system, because there was pressure in the insurance industry to reduce costs of claims. So the Financial Services Commission of Ontario, the Insurance Bureau of Canada, I guess, came up with this guideline that puts people in a certain category. People who have suffered sprains, strains, contusions, lacerations, partial tears but not complete tears of ligaments and tissues and things like that. So they allocate $3,500 worth of treatment for these type of injuries. What we're having a struggle with is people that are somewhat more seriously injured that are having trouble falling outside of this minor injury guideline. There are exemptions to the minor injury guideline, and these include neurological conditions, pre-existing conditions that may provide a barrier to a person's recovery,
Right.
and maybe a psychological condition. In
Right.
other words, everyone has some sort of acute psychology when they're following an initial stage of a motor vehicle accident. But if this psychological illness or disturbance persists for a period of time, this may also create a barrier to the recovery. So there's ways of not being classified as a minor injury. And the roadblock we're having, and the problem we're having, is these type of injuries that are more serious is getting people outside of this minor injury guideline. Yes, we know people can be treated with soft tissue sprain strains within a time frame. But what happens when these people don't recover within that time frame? What happens when these people exhibit psychological disorders? What happens if these people have symptoms of neurological disorder? What do we do from there? The best thing to do is obviously get the family physician involved right from the get-go. Let them know the injuries, let them know possible barriers. Get as much information as you can from the family physician as to the pre-existing medical condition of this patient that may pose a barrier to recovery, whether it's a previous back injury, whether the client's been on disability, when the client's got some osteoarthritic changes, stuff like that. So keep the doctor informed, and let's say the insurance company have the choice to either, when we submit a treatment plan, we can either submit a minor injury guideline treatment plan, or we can submit a treatment plan that goes above and beyond the minor injury because we believe that the injuries are not of a minor nature. So we usually get the doctors involved in having our treatment plans reviewed and approved by the physician, who is the family doctor of this patient for how many years. And then we submit them to the insurer. And the insurer has the option to either approve the treatment plan, partially approve it, or deny it. And when they deny it, they usually send it to an insurance examination, what will then give us a medical opinion as to whether this patient's injuries are within the minor injury or not.
Okay.
And that's where we go.
And I understand that it's the insurance company that deems a client or a patient, if you will, to have a minor injury and thus subject to the minor injury guideline.
Right.
So it's up to them to do that.
Yes.
And it's also been my experience since 2010 that they've been very liberal in deciding who goes in and who's out of the MIG. Would you agree with that?
Yeah, we've seen a drastic rate of clients being put in the minor injury guideline. We're talking like 70 to 80% of injuries that fall within this minor injury guideline. The issue is, what do we do after this guideline?
Right. But so they're putting most of the people in car accidents into the MIG.
Correct.
And you don't necessarily, and I certainly don't necessarily agree that most of them should be there, although clearly some people should be there. And so what you're trying to do, and I can tell you, and you know this, that What I'm trying to do from my legal perspective, and you have the other side of the coin there, the treatment facility perspective, is we're trying to get them out of the MIG. And the reason we would want to do that is clearly if we get them out of the MIG, then they are entitled to not $3,500 in treatment, but $50,000 in treatment if they're not deemed to be catastrophically injured, which is another topic altogether.
Right.
Right. And so that's your goal, to try and get them as much treatment as they require.
They require, correct.
All right. And again, so the ways you're doing this is either perhaps through pre-existing problems that would form a barrier to their recovery. That's one way to get them out of the MIG. A psychiatric or psychological ailment as a result of the accident, that would be another way to get them out of the MIG. And perhaps even a neurological impairment.
Correct.
And just so people understand, though, that this MIG is quite controversial in my understanding. So, for example, I could have a 99% tear in one of my muscles. I mean, my arm could be sort of hanging off this 1%, but because it's not a complete tear, I'm still considered to have a minor injury,
right,
and to be subject to the MIG, this minor injury guideline, and I have to get better somehow on $3,500 worth of treatment.
Correct, and that's why we get the family physicians involved and get the proper referrals to the proper specialists to be able to provide, because part of the minor injury guidelines is to provide compelling evidence of injury. So
pre-existing injury.
Pre-existing injury.
Right.
So part of this is to obviously provide some diagnostic information, evidence-based information as to whether these injuries are of a more serious nature. So we have a huge difficulty in trying to acquire these type of services as far as MRIs go, because there are changes to the MRI referral process that doesn't allow physicians to make referrals for unnecessary MRIs now.
And OHIP won't pay for them.
OHIP won't pay for them.
Right. So who would pay for them then?
Well, we're trying to get the insurance to pay for them.
Right.
However,
but they're hiding behind the MIG.
They're hiding behind the MIG. They're saying that OHIP is responsible. If it's an OHIP provided service, then OHIP's responsible for paying for it.
So the auto insurance companies are saying OHIP should pay for it.
Right.
From my understanding, the OHIP legislation says they don't pay for it if it's as a result of a motor vehicle accident.
Right, or if it's a purpose of medical rehab benefits,
right,
things like that.
Right. And who loses in that game?
The claimant.
Right.
The claimant. Eventually, this always falls onto the claimant. The claimant doesn't get the necessary diagnostic tests to prove their injuries, and then gets hence sucked into the mediation process of having to go through the legal process of filing for mediation, as you had also said previously, that this mediation process can take up to a year.
Right.
So telling an injured person that they have to wait a year to have a denied treatment be mediated is absurd.
It's absurd, right? And so, in the meantime, they're not getting any funding, no treatment.
Right.
And who do you think benefits from this new system?
Well, obviously the insurance.
Insurance companies.
The insurance companies. They're not paying out for treatment,
right,
because it's been denied, and then we are in a predicament where we can either provide that treatment on a promise to pay basis for the claimant. If the claimant really needs it, and he says, I'm benefiting from it, they'll attend treatment, whether it's a watered down version of maybe once or twice a week, depends on the claimant. And it's so complicated. This is why they need legal representation. In order to navigate through the mediation process, you need to have a representative, or else an injured person trying to do this on their own is nearly impossible.
And Jim, I was going to ask you the next question, but I'm going to answer it myself, is what do you see any change in the future? But I can tell you that, and I can tell the folks out there that personally, and we at Pace Law Firm, that's our job, and you mentioned that's why they require legal representation. And we're trying to fight this MIG guideline and the minor injury wording in the legislation as much as we can. We're trying to weaken it, if you will. If we weaken these regulations, then we expand the scope of what our clients and what your patients are entitled to. We want to expand the scope of what is compelling evidence, what is a pre-existing injury, what is a barrier to recovery, what is a psychiatric disorder arising from the accident.
And when you say expand, I think even to clarify or define.
Sure. Well, we want to
define these areas so we know what we need.
Right, and we're trying to define it legally, but define it legally and get legal rulings from arbitrators and courts that benefit our clients and in turn allow them to get out of the MIG quicker, for more of them to get out of the MIG so that they can come and see you and your facility so they can get the treatment that they deserve.
Right.
That'll make them better. And that's where we're going.
Yeah.
All right. And folks out there, if you want to check out any more updates on this topic and other topics, please take a look on our website at pacelawfirm.com.